Well, happy hump day, everyone. My name is Aaron Parry. I'm a consumer protection compliance attorney focusing on marketing and advertising and data privacy here at McMurray and Schuster. And today we have an exciting webinar to delve into three critical areas that will kind of shape the telemarketing landscape in 2025. First, we'll explore the Supreme Court's review of the Hobbs Act in the McLaughlin case. The challenge to the Hobbs Act centers on whether district courts must adhere to FCC interpretations of the TCPA. And then next we'll dive into the IMC case, the portion that everyone wants to hear about. As we all know, the Insurance Marketing Coalition is challenging the FCC's one-to-one consent rule, and we're excited to talk about that and the possible implications there. And then finally, we'll examine the Do Not Disturb Act. That's a federal bill that was introduced last year to amend the TCPA. And the Do Not Disturb Act has not yet been reintroduced into the new Congress, but it's important to review the key provisions of the act and talk generally about federal and state legislation we may see in 2025, possibly because of the Hobbs Act review and the IMC case. But before we get any further, I do have a few housekeeping items. This webinar is being recorded. It should be available early next week. We'll send an email out when it is available. If you want to rewatch or share with a colleague, you'll have the link to do so. Next, we've received tons of questions in advance of this webinar. We hope to get to all of those questions naturally in the course of the webinar. If we don't, put that question back in the Q&A or put any new questions in the Q&A box at the bottom of your screen there, and we'll try to get into that as we go along. If we cannot, we'll be sure to take care of it through email. Lastly, I wouldn't be an attorney if I didn't give a disclaimer. So this presentation, and this is for all three of us speaking, this presentation is for informational purposes only and does not constitute legal advice. What we provide here does not create an attorney-client relationship. Each situation is unique, so we recommend consulting your attorney before acting on any of the information in this presentation. We would love to be your counsel, so we can help if you do have any of those questions that come up. So I'm pleased to introduce two of the absolute most stellar minds in the telemarketing industry who will be sharing their thoughts today. Spencer Elg and Michele Shuster. Spencer, introduce yourself really quickly, please. Michele, do the same.
Thanks, Aaron. So I am general counsel at What If Media Group, which is a digital marketing company. I was previously general counsel at DataLot, which is now Centerfield Insurance Services, which is also a digital marketing company. I did a stint at a law firm where I defended class action litigation. And before that, I was at the Federal Trade Commission where I sued illegal telemarketers and fraudulent advertisers. And to just add on top of the disclaimer that Aaron already provided, I will say that my company is one of about 50 companies that make up the Insurance Marketing Coalition, which we'll talk about. They've challenged the FCC lawsuit. My comments are my personal comments. They are not comments of IMC, and they are not comments of What If. And with that, I'll leave it to Michele.
Wow, that's lots of disclaimers. I have no disclaimers. Privilege of working with Aaron Parry. That is my great distinction. And I think Spencer is one of the smartest guys I know in this industry. So I'm very happy to be a part of this webinar. I am managing partner at McMurray and Schuster. And like Spencer, I'm a former regulator, but on the state side rather than the federal side. But I imagine we were working on the same types of issues when we were in those offices, a lot having to do with the do not call regulations, and definitely for my part, the multi-state actions that frequently came out of the attorneys general's offices. And I think this is going to be a really great webinar. Hearing about what IMC is doing, I think will be of particular interest to people. I really applaud the position that IMC has taken, and having been in the position previously with trade associations for appealing FCC's orders, it is a thankless and not easy job. So Aaron and Spencer, thanks for being part of IMC and championing that. So with that, Aaron, I have no disclaimers. I think we're ready to go.
Hey, well, thank you both. And so I think I speak collectively. By the end of this, we hope that you'll have a solid understanding of how these critical areas may reshape the telemarketing industry in 2025. We'll throw in some practical insights along the way. But before we get into the substance, I just want to spend a few minutes to remind everyone of the federal legislative and regulatory process. I think this will be a helpful backbone for our conversation. So as you know, and we could have played the schoolhouse rock, how a bill becomes the law, but I'll sing a little bit here and I'll just kind of mimic that for us. So we start out with the introduction of a bill that a member of either the House of Representatives or the Senate can introduce a bill, and it typically goes straight into a relevant committee that specializes on the bill's subject matters. They'll review the bill, hold hearings, make any committee amendments to the bill before sending it on for larger debate and voting on the respective House or Senate floor. That's the time that the full membership discusses the bill, proposes further amendments, and votes on the bill. Typically requires a majority vote in both chambers to pass a bill. It then goes to the president to approve. President can sign the bill into the law or veto it. If he vetoes it, the Congress does have the ability to override the veto with a 2/3 majority vote. Once the bill becomes a law, especially nowadays, it often has provisions that delegate authority to federal agencies. And the agencies are tasked with creating detailed regulations to implement what the text of the law said. And the bill only has to give certain guiding principles for this delegation of authority. And agencies will follow those guidelines, and they have a structured rulemaking process that they have to follow too. That typically includes drafting proposed regulations, giving a notice and a public comment period, and then finalizing the regulations. The process is governed by the Administrative Procedure Act, a law that I'm sure that you've heard one way or another. Now, Congress does retain some oversight of the agency's rulemaking activities, and it can modify or repeal agency regulations by law, by passing another law. One last important part that'll come up when we talk about the Hobbs Act here in a minute is declaratory rulings. Federal agencies also have the authority to issue declaratory rulings to clarify the application of a certain law or the regulations that they administer. And the declaratory rulings typically help resolve disputes or kind of provide more certainty by giving an official interpretation of the specific issue. So just remember that agencies can issue these declaratory rulings on their own initiative or in response to a request, and these carry the same legal weight as other agency actions and have to be reviewed by higher courts. So jumping into the first part here, I'm going to give a brief overview of the Hobbs Act, and we'll jump right into to get some thoughts from Spencer and Michele. So the Hobbs Act gives the Court of Appeals the sole authority to decide if certain agency actions, including final orders from the FCC related to the TCPA, are valid. In the McLaughlin versus McKesson case, which is the case that the Supreme Court has decided to hear to resolve this issue, the petitioner, McLaughlin, had sued McKesson in federal district court, claiming that they violated the TCPA by sending unsolicited fax. During the case, the FCC issued a declaratory ruling, what we just walked through, clarifying that unsolicited faxes sent to an online fax service did not violate the TCPA. The district court had to follow the Hobbs Act, had to accept the FCC's clarification, and dismissed McLaughlin's TCPA claims. The Court of Appeals agreed with the decision, and we landed where we're at today. The Supreme Court is facing the question whether the Hobbs Act's vesting of exclusive jurisdiction in the Court of Appeals bars collateral attacks on an agency action in district court litigation. So Michele, I'll flip it to you first. Can you highlight the importance of the Hobbs Act as a procedural mechanism in TCPA lawsuits? And then can both of you touch on how the parties are briefing the issues surrounding the Hobbs Act?
So let me start with something way more interesting than Hobbs Act, and it's why the Hobbs Act was passed. And so the Hobbs Act actually goes way back to the Prohibition era. And it was specifically addressing some of the harms that the government was seeing with labor relations, as you can well imagine, back in the Prohibition era. And so the Hobbs Act was passed to give the FCC jurisdiction to pass rules that would guide what was a violation of federal laws, of these regulations. And, the purpose of that was that the FCC needed to be nimble if they were going to be able to keep up with the Prohibition era gangsters. And so just putting it in the historical context of why it was created and what it was used for. And so in practice, how this works, and specifically with the TCPA and these new one-to-one consent rules that go into effect at the end of the month, you look at the fact that the FCC has gone through that process that Aaron has just described. And at the end of that process, they came out with this one-to-one consent rule, which at the heart of what we're really talking about today had two requirements that are extremely problematic for companies that are looking to get consent to call consumers. One of those being the requirement that consent be obtained on a one consumer to one seller basis, and that any lead form used to collect consent, and particularly online, that the subsequent call that would be made would be in line and logically and topically related to the content on that website. And so, in looking at the Hobbs Act, the FCC went through the proper procedure to pass the new one-to-one rules. And if those rules were to be challenged based on the Hobbs Act, they have to go directly to the circuit court. And also, in the meantime, as this is being challenged, and Spencer is going to talk about the IMC challenge here in a moment, but as these rules are being challenged, any district court that hears a case on the TCPA that is affected by these new rules will be required to follow the ruling that was issued. The rule that was issued by the FCC. So it has significant impact on the TCPA and the requirement for the district courts to follow what the FCC has put out there.
Yeah, I would say, from a business perspective, that we've done a lot of kind of talking about the mechanics, but just from a business perspective, how this plays out is, let's say my business gets sued in a TCPA lawsuit, and I want to assert a defense. So for example, let me just make one up. Let's say my defense is I've been sued because I sent a text message, and my defense is text messages aren't covered by the TCPA. In fact, text messages, they didn't exist when the TCPA was enacted. So the reason text messages today exist under the TCPA is because the FCC has said they do. And under the Hobbs Act, the district courts, if my company gets sued or your company gets sued, they're required to defer to the FCC's decision on whether or not that applies under the TCPA, and that we would apply for anything under the TCPA, anything that you disagree with about what an agency said about us, about the TCPA. Even if you don't think it's in the statute, even if you think that the FCC got it wrong, you cannot bring that up in court under the Hobbs Act as it currently interpreted. And so that's why this case is a really big deal, is because over like the last 3 decades, the FCC has entered tons of orders about what the about what the TCPA means as a statute. And if the Hobbs Act does not prevent companies or plaintiffs, because this case we're talking about was actually a case brought by the plaintiff that was appealed. But it essentially, if the Hobbs Act does not have this ability to prevent folks from arguing in court what the TCPA means, then these interpretations that companies have relied on over the years that the FCC has promulgated could all be unwound. And you could find yourself in court kind of fundamentally trying to figure out what the TCPA means word for word all over again.
You brought up an interesting point. Those previous orders and regulations could all be unwound. Is it as simple as if the Hobbs Act requirements no longer apply, would all of those previous rulings and regulations just be out the door, or would they have to be kind of tossed out on an individual basis?
So I don't think everything gets unwound. All that the Hobbs Act says is that you can't challenge those in district court in a private lawsuit, right? You just have to defer to the FCC's prior decision. The courts have to defer. So if the courts were to, if the Supreme Court were to limit the Hobbs Act, and there's a couple different ways they could do it. It's probably not blowing up the Hobbs Act. It's one of several other possible avenues, but the outcome would be that if you were sued in a lawsuit, you would now have the ability to argue in that lawsuit that the FCC got it wrong. And you would still have to prove your case. And the judges probably, even though they may not be required to provide deference, they're still going to probably, as a practical matter, provide deference to the FCC. But it does provide a powerful tool potentially for defendants to make arguments that they would not be otherwise allowed to make. And conversely, it probably provides a powerful tool for plaintiffs to make arguments that they would otherwise not be able to make.
And thinking ahead to a possible ruling, I'm interested to hear each of your thoughts on whether on the outcome of this case, and whether the Supreme Court Chevron decision provides any insight on how the court might rule.
That's interesting, right? So the court that we currently have is a majority made up of Trump appointees. And so we do know that when Trump was when he was appointing judges, both for the Supreme Court and other courts around the United States, he was definitely looking at their tendencies with regard to application of the law. And so we saw that with this Chevron deference being overruled in a case last year. And Chevron deference, a little bit different, but very similar to the Hobbs Act, in that there was a standard out there that the district courts had to defer to administrative agencies that were responsible for interpreting their laws. And so the Supreme Court looked at this issue, and they thought that what had happened was an unreasonable delegation of powers to the administrative agencies to basically make law. And so they thought that was unconstitutional, and that those administrative agencies that Aaron had described, like the FCC, are responsible for implementing it, not making that law, except to the extent they've already been granted an authority. And so it overturned that deference that had been in place for decades now, that required, again, district courts, the trial courts, to defer to prior agencies' rulemaking and interpretation of those statutes that they were responsible for enforcing. So, I mean, who knows? I mean, I wouldn't want to place bets on this, although I am interested to hear what Spencer says about some of this. But, I do think that there may be a tendency towards that. And, if we don't have the Hobbs Act anymore, as Spencer described, it'll have a significant impact in the TCPA world.
Yeah, so my bet on this, and again, it's a bet, but I think the Hobbs Act will probably likely, it's going to survive, but the ability of parties, companies, and plaintiffs to argue in private, in litigation, that the FCC got it wrong is going to increase. And it's going to increase in either one of two ways. One is just that as a general matter, anybody's going to be allowed to argue anytime in district court that the FCC got it wrong. That's one possibility. Or the other way that it might happen is the court may say, well, look, if your company wasn't around, or if the plaintiffs, if you weren't around when the agency took this action and you didn't have an opportunity to participate, then you're allowed to argue in district court that the FCC got it wrong, because it's just unfair. How can you be bound by something that you didn't have any opportunity to participate in? So my money is on one of those two scenarios, but it's a guess. We'll see.
And I'm a admin law lover, so I just am interested on both of your thoughts on the broader implications of this case for administrative law and agency deference. It feels like the administrative state is under attack, and there's pros and cons to that. What are your thoughts on the broader implications of this case, just for administrative law in general?
Well, it's interesting because you heard President-elect Trump's statements in his previous campaigns for his previous presidency, talking about draining the swamp. And when he was talking about draining the swamp, this is pretty much what he was talking about, getting rid of the very strong authority of these administrative agencies to enact laws, in essence, to do what Congress does through their ability to interpret statutes, and that ability to interpret being very broadly applied based on things like the Hobbs Act and Chevron deference. And so, it will be interesting, very interesting to see how this plays out.
Yeah, look, I think that the Supreme Court, with the current constitution of the justices, has made it crystal clear in recent cases that they do not think that agencies should be legislating. Agencies are part of the executive branch. They are supposed to execute on what Congress has done. And judges, the judicial system, is supposed to be the backstop. And I think the justices fear that the agencies have gone too far in making law as opposed to implementing the law. And I think that's a trend we're going to see across administrative litigation over coming years.
I think most businesses, when they hear us talking about these types of things and that, what the FCC has done will be undone, they really only think about those things that they are having difficulty complying with one-to-one consent, logically and topically related type of standards. But there is interpretation out there from the FCC and other federal agencies that's also helpful. I mean, one example that comes to mind instantly is the prior express consent you need for certain types of telephone calls that's not required to be written. And what the FCC has said is that if a consumer provides their cell phone number as a means of being contacted, and a company is subsequently contacting them within that means, then that's deemed to be the type of prior express consent that allows you to use the regulated technology to call them. And so, it's interesting to think about. It's not just those ones that we're not real happy about having to comply with. There are some out there that are also good for us. The fax case, the McLaughlin case, is a good example of that. It had, narrowed the reach of the type of the type of consent that was required for faxes and what types didn't require a consent. So it would be if all of these are undone, it would be very interesting to see in the aftermath what happens. And I suspect what happens is there's a lot more litigation, because now, companies, plaintiffs' attorneys are going to want to be out there establishing law now, so that they'll have that to rely on, as opposed to the agency interpretations and deference.
So it sounds like it may lead to inconsistent interpretations across districts regarding meanings of certain terms and applicability of certain provisions. So it sounds like the in this case, businesses would definitely need to enhance their telemarketing compliance procedures to adapt to the evolving case law, especially those businesses that have been relying on favorable FCC orders.
Yeah. And we've got a really great example of that recently that we've all lived through. And that was, what is the definition of an automatic telephone dialing system? And so that was an area where when the FCC's interpretation of what an ATDS was overturned, we then had courts going in all kinds of different directions. And so we had some circuits taking a very narrow definition, or applying a very narrow definition of what constituted an automatic telephone dialing system under the TCPA, and then others taking a broader. And so that led to that issue going up to the Supreme Court, which resulted in the Facebook versus Duguid decision. And so we have a really good example of what that kind of chaos looks like, and kind of the effort it takes to get to the end of that.
Yeah, great point. So that's kind of the vehicle for challenging FCC orders or regulations. So now let's shift to the bread and butter here, the IMC challenge. As everyone likely knows, the FCC finalized their huge revision to the definition of prior express written consent in late 2023. We know that prior express written consent is required to make calls using regulated technology. If you need a refresher on what PWC is needed for, we have these handy dandy cool charts that I use all the time that I'm happy to send to you. Just shoot me an email and we'll get that right over to you. Effective in about 12 days on January 27th, prior express written consent must be obtained in a written agreement, which includes the signature of the person providing the consent. The agreement has to specifically indicate the single seller to whom consent is being provided. It also must contain the telephone number the person consents to receive calls at. The consumer must take some affirmative action to indicate their assent. And the content of the calls or texts must be logically and topically related to the content of the website where the consumer provided the consent. So big rule changes here with that definition of prior express written consent. About a month after that rule was issued by the FCC, the IMC filed a lawsuit in the 11th Circuit early in 2024, challenging the one-to-one consent rule. So Spencer, I'll toss it to you. Can you give us an update on what's going on with the IMC case and what we think is going to happen?
Sure. So IMC participated in the FCC rulemaking. They expressed concern that the FCC had exceeded its statutory authority, because we talked about the difference between the statutes and then the agency rules. All that the statute says about these types of calls is that in order to receive them as a consumer or in order to initiate them as a business, all that's required is, quote, prior express consent, unquote. So all of those requirements that you just ticked off, the signature, the phone number, the one-to-one, the logical and topical, all this, not in the Telephone Consumer Protection Act, not in there. Literally all the statute says is prior express consent. And IMC's legal challenge makes essentially the same arguments that it made fruitlessly at the commission, which is that the commission, the FCC, exceeded its statutory authority by requiring more than is what is required under the statute. And IMC pointed to a variety of case law in the 11th Circuit Court of Appeals, where the 11th Circuit has previously held that under the TCPA, it is permissible for multiple parties to be consented to in a single transaction. They cited to the definition of express consent in Black's Law Dictionary, which says it's permission that's I forget what the exact wording is, but it's unmistakable and it's clear. And those arguments that were advanced by the FCC, by IMC, by the Insurance Marketing Coalition, they were echoed significantly in oral argument that was held in the matter. And so there's a panel of 3 judges that will decide this case. Those judges heard oral arguments from both sides, from IMC and from the FCC. And the judges seemed incredibly receptive to IMC's core arguments that the FCC had exceeded its statutory authority, that the one-to-one and the logically and topically associated rules conflict with the plain language of the Telephone Consumer Protection Act, and that the FCC could not purport to implement a statute when it was restricting the rights that the statute gave for consumers to receive those types of calls that they consented to. And so that's kind of where things are right now. The effective date of the statute, which is January 27th, makes this really tricky because the court just heard oral argument in late December. And so there's a variety of scenarios that could play out here. That's kind of the current status of, what the challenge is and where it stands. It's fully briefed. There's been oral argument. And as of today, at least as of an hour ago, when I checked the public docket, there has not been an order entered by the court.
So what do we think is going to happen and when? Is this something we'll find out, tomorrow or within the next 12 days?
Well, I'm heavily biased and I'm not objective, so take it all with a grain of salt. But so Michele, feel free to throw a devil's advocate or counter argument here. Keep me honest. Rarely at the appellate level do you see judges that appear for significant parts of the argument to be reading from the brief of the challenger. The judges, they cited IMC's definition from Black's Law Dictionary. They adopted IMC's argument that this was an issue of limiting consumers' rights to obtain calls that they want to receive, which was the opening line of IMC's merits brief. They extensively used some diagrams that IMC's attorneys had created to kind of demonstrate visually the absurdity of the rules. And they used those diagrams to pin the FCC's attorneys down to the point where he couldn't, he was kind of flummoxed for a response. And the reason I mention those things, I think those are all indicative that the court, really came into this argument having determined that they thought IMC had the stronger argument. I don't see anything at oral argument that would lead to a different conclusion. And near the very end of oral argument, IMC's attorneys, it was a very hot panel, lots of questions, and they tried to squeeze in IMC's attorneys tried to squeeze in a comment about the timing of the rule. And it had barely escaped IMC's attorney's lips that this rule was scheduled to take effect January 27th, when one of the judges cut off the attorney and asked if there was anything that would prevent the court from staying or from enjoining or from stopping or pausing or calling a timeout on the rule going into effect while the litigation played out. And IMC's attorneys responded correctly that no, there's nothing, legally to prevent that. And so what that demonstrates is that the timing of this was on the minds of the judges walking into the hearing, that they had thought about it, that they understand that there is, it's not the implementation that's trying to be stopped at this point. The implementation has happened. It's January 15th. You've spent the time, the money, like our company has. Michele and Aaron, you have helped countless clients with these issues. The work is done, right? So at this point, but the court understands that it's not the implementation. It is, the inefficiencies that are going to be created in the marketplace by these arbitrary rules. And then it's the private plaintiff's bar, which is going to capitalize on these changes to bring, lawsuits to stretch the boundaries of this as far as possible and find where they can have traction. And I think the judges understand that. My bet on this, and I'm wrong all the time, but my bet on this is I think we will see vacator of the rule, meaning the rule just gets blown up by the court, or we will see a stay issued by January 27th. Now, a couple days ago, there was a 25% chance of rain. I left my house without an umbrella and I got soaked. So, beware, but that's my bet. Now, Michele, feel free to, counter that if you disagree.
I'm trying to figure out if you're thinking that appellate courts are more or less easy to predict than the weather.
Yeah.
Anyway,
Often not.
This is the fun stuff to talk about, right? Because, making predictions and those types of things. And so, I took, first of all, I just want to say that I love the fact that IMC focused on the fact that the FCC's rulemaking actually took away consumer rights, because the FCC would see itself as a consumer protection agency in terms of how it enforces the TCPA. So I love that. I love it that the court picked up on that as well. And I thought when I heard that boded really well for what the court was thinking. I also, we took all of the oral arguments. We took the makeup of the 3-panel appellate court that heard this appeal, and we put the briefs into our AI software, and we asked it to predict the likelihood of IMC's success in its appeal. And you'll be happy to know that AI thought it was more likely than not that IMC would be successful. So I don't know. I'm just going to leave it at that for a prediction. We'll see how good AI is at this point. But even just getting excited about the fact that maybe these don't go into effect. Spencer is right. A lot of companies, probably the majority of them, have already taken steps to comply with this. But a couple of things about that, though, is when you're working with clients and when clients are considering exactly what they're going to do to meet these new requirements, which are greatly limiting their ability to get consent, and a lot of them, even their ability to stay in business if they take a very hard-lined, black and white letter of the law approach to what the FCC has said. And so businesses, as they're implementing these regulations, or at least attempting to implement these regulations, are being required to make some really difficult decisions that are, Michele and Aaron and Spencer, what do you think these mean? And then, based on what is this going to be enough to comply with that? Can we select individual sellers within a lead form, and will that be okay? Does it have to be below the button, above the button? What exactly does clear and conspicuous disclosures mean as far as prior express written consent? And to top it all off, to make it even worse, we have plaintiffs' attorneys that are already filing lawsuits that are alleging that one-to-one consent is already required by the black letter of the TCPA. And, they are relying on the fact that the definition of prior express invitation for do not call talks about getting consent from a seller or from a consumer to that seller, implying a seller. We have AGs that filed comments that said that they believe at the time the FCC was looking at implementing these new regulations, that the FCC wasn't required to do that because the regulations already held that. And so I would say, regardless of what happens with this IMC appeal, it's going to be a very rocky ride out there for a while. And I would encourage any business that's looking at what they need to do to make sure that they are not among that group of businesses that are getting sued right out of the gate for plaintiff's counsel to attempt to make good law that then, courts, depending upon, we won't get into the district versus circuit, but all of that, but courts in that jurisdiction would be required to follow. And so, my strong recommendation to all of you out there is really, take a look at these, and we have to move forward as if they are going to go into effect. And even if they don't go into effect, we're going to have plaintiffs' attorneys arguing that they apply anyway. And so have a defendable position, find good counsel out there to advise you on how you can have that defendable position, and make sure they understand the landscape enough from what courts have already decided to know that you are going to be in substantial compliance based on especially what your risk level is for putting together those types of consent languages and what you're going to require of your lead generators and affiliate marketers. So, that's my really strong recommendation.
Yeah, and I think, go ahead, Aaron.
No.
I was just going to say, I think that one of the effects of this proposal by the FCC, and it's been healthy, is I think that there has been a lot of attention paid by industry, on how can we improve the way that we obtain consent from individuals to be called? How do we make sure that we are, not muddling consents, and they're understanding what type of calls they're going to get, and it's within their reasonable expectations. And I don't anticipate that those practices are going to go away. Some of the rigidity, I don't know if that's a word, but some of the strictness of this rule, I do think that will go away because it's illogical. But making sure that folks who go through your web forms, or if you're doing this by paper, that go through your paper forms, understand, and they expect to get the calls they receive. That's a really healthy thing. And I think if there's any silver lining of this horribly painful implementation process, it will be that.
Yeah. It's that standard of clear and conspicuous, and your language has to make it readily apparent to the consumer that as a result of filling out this form, they're going to receive a telephone call. And if technology is going to be used, that type of technology that requires consent, pre-recorded messages, artificial voice, an automatic telephone dialing system is in that disclosure language as well as those other kind of technical, no consent required, those types of things, and CTIA standards. There's just so much really you need to get into that language, but there are ways to do it that will effectively convert. And Spencer, no one could probably speak better to that than you, since that's the business you're in.
Well, we try, and as with all businesses, there's always, room for improvement. Another kind of interesting thing about this case, and this is kind of the broader landscape, is that regulators, and you mentioned the state AGs and all these public interest groups and so forth, Michele, they're not going away. Unwanted calls are a problem. Now, according to the FTC, they're less of a problem. The FTC issued a report in November saying unwanted calls were down 50% since 2021 without this rule existing. But setting that aside, this is still a serious issue for regulators, legislators, private interest groups, and so forth. And so even if this rule gets set aside, I think legislators and agencies are going to continue to throw stuff at it to try to address the problem, even though I personally think it's more of an enforcement than a rule problem. And I think we'll see that. We'll continue to see efforts to try to impose legislation or agency rules to try to address what the FCC continues to perceive as a problem.
Yeah, and I see the FCC continuing down this path of making voice service providers and carriers responsible for policing telephone calls. Now in order to get phone service, telemarketers are required to establish that they are not making robocalls, and that would be interpreted as making calls for which they don't have consent. And the threat is that if you as a voice service provider or a carrier are allowing this illegal traffic to originate from your platform, then you are not meeting these requirements that are called robocall mitigation requirements that must be in a plan that is filed with something called the robocall mitigation database. And if the FCC determines that you are not effectively implementing or don't have an effective robocall mitigation plan, they can pull that from the robocall mitigation database. And then carriers are required to refuse your traffic. And so, they've implemented this whole level of the police state that has nothing to do with any type of elected individual or entities or administrative agencies that have to follow rules. It's now the voice service providers and carriers that are enforcing these.
So the interplay between the Hobbs Act and the IMC petition, what will happen if the 11th Circuit rejects the IMC petition, upholds the one-to-one consent rule, but the Supreme Court rules that a district court is not bound by the Hobbs Act? What's the interplay there?
Yeah, so if you're on the the company side of this, not the plaintiff side of this, if IMC wins its lawsuit, then you want the Hobbs Act to stay in place as is, because it means that the plaintiff bar can't go and collaterally attack, that. If the IMC loses its lawsuit and the FCC order stays in place, then you want the Hobbs Act to get narrowed so that you can go and collaterally challenge it in district court. So it's kind of this interesting interplay. And as Michele said earlier, this thing with the Hobbs Act absolutely cuts both ways.
And if the Hobbs Act were to get blown up, would that do away with NPRMs from the FCC, or would we basically just be left with the courts determining what this statute say? So would that take away that other part of the APA, which requires notice and comment before implementing regulations?
So they're going to be going back and looking at those statutes that were passed by Congress and what type of authority was delegated to these administrative agencies, and administrative agencies will really be required to act within that. And if not, then risk facing a challenge in court, much like IMC is doing right now. So, the only thing that's certain about all of this is that the lawyers are going to be very busy no matter what happens, because no matter what happens, it is going to be a new era of defining what all of these types of things mean by the courts. And even if given deference to the FCC moving forward, there's still a lot of room for interpretation. So, we will all be very busy.
Right. And to knock out a quick question we got about what the one-to-one consent applies to, it only applies to regulated technology. It's using an ATDS or a pre-recorded message. But another question is, even if there's a pause on the one-to-one consent by the requirement by the FCC, the TSR's one-to-one consent requirement still exists. Is that right? Could you guys, and you guys both kind of touched on it, but could you elaborate on that question specifically?
That is a topic that's just near and dear to my heart, I have to tell you, and this is why. So it's a PACE conference, I don't know, 2 or 3 years ago. Time seems to be going way too fast now. I was interviewing Lois Greisman on stage, and she said from the stage, Michele, I just want to make sure that you are all hearing me, that you need to get consent from one consumer to one seller if pre-recorded messages will be used in telemarketing calls. And so I was like, okay, well, that's great. That must mean that they're looking at making some type of rulemaking or something like that. And she really meant that. She meant that that is something that the FTC was interpreting as a requirement to then. And instead of any type of rulemaking or anything that would have been done through the Administrative Procedures Act that Aaron is talking about, the FCC issued something in their guidance document, which I think for the most part is pretty incredible, called Complying with the Telemarketing Sales Rule. And they went through and amended their kind of guidance that they give, or, they like to put detailed bones on the telemarketing sales rule as to how companies should be implementing that. And they put a line in there with a sentence that basically said that if you are using a pre-recorded message, the telemarketing sales rule, it requires that if that's done for telemarketing purposes, you have to get consent from a consumer to a seller. for that because of the language of the telemarketing sales rule. So that's still out there. I will say that for the most part, companies do worry about the telemarketing sales rule because it is enforced by the Federal Trade Commission, and the fines are outrageous. It's 40,000 and something. Actually, it may be over 50,000 now for each telephone call. So it's astronomical amounts. And in addition, while there's no private right of action, so that's why you don't see plaintiffs' attorneys filing class actions around the TSR, all of the state's attorneys general have the ability to enforce the telemarketing sales rule. So there is significant exposure on the regulatory front for that. So it's that's an interesting area in and of itself too, and I think maybe subject to a challenge moving forward.
So to tie this topic up, in my opinion, I think a ruling in favor of the IMC may lead to more cautious and narrowly tailored regulations, but a ruling in favor of the FCC could embolden them to pursue more stringent consumer protections. Could you both give me one practical implication for businesses if the challenge is successful and if the challenge is not successful?
Spencer, do you want to take the lead?
Yeah, so I think if the challenge is successful, the practical implication for businesses is clear, which is this rigid one seller, one web form, no deviation whatsoever between the website and the type of consent being generated. That goes away, and your risk profile is significantly mitigated, with respect to challenges that would be brought. If the rule is upheld, everybody has done all the implementation. I think there's going to be, buckle up for the ongoing litigation. And this is one of the reasons why it's so important to have good counsel, like Michele or Aaron, is because as the courts decide these cases, it's really important to know which way they're deciding them and what the reasoning is, so that you don't set your practices in stone and you're not adjusting them as the law adjusts. I mean, you can really get burned if you have spent all this time and effort developing a compliance strategy, and then you're not paying attention to developments in the law that would, necessitate some tact or some change in your approach. And so, it's always important to keep an eye on that. But I would say, especially if the rule goes into effect, because there's so much uncertainty about what certain parts of it mean, it's just really important to keep your ear to the ground and to be able to adjust quickly as things become clearer.
Yeah. And I also think on the other side of that, Spencer, if it doesn't go into effect, I think that based on all of the comments that have been filed out there and what the governmental agencies at all different levels are saying it already means, I think we're going to have significant litigation around that as well. And I think everything you just said applies to that as well. So this is just an area that if you're in this industry and if you're a seller relying on lead generators, you need to really pay attention to what's going on, because when cases are issued, that means that the decision in that case for the area that it applies to, that the law has already said that is what the law means. And so being able to be nimble and understanding what your practices are now, so in case you have to change them, you'll know where you need to change them, is going to be really critically important.
Yeah, great input there. So to get into our last topic very quickly here, we just wanted to talk briefly about how states and the federal government may address these telemarketing changes in 2025. In 2024, we saw the Do Not Disturb Act introduced. It was a federal bill that sought to amend the TCPA. It died in the last Congress, but it had some very powerful provisions in it. It introduced a definition to robocall for the first time, and it was a pretty substantial definition. It kind of hinted to reintroduce the human intervention test. It also defined text message to include essentially any messaging available today. It also had maybe the most drastic change was the call time restrictions. Telemarketing calls right now are permitted from 8 a.m. to 9 p.m., but under the Do Not Disturb Act, it would have been restricted only to 9 a.m. to 5 p.m. There's AI disclosures, enhanced penalties for AI voice or text messaging. They even included several VoIP requirements, a top 100 illegal robocall campaign list. Pretty substantial bill. On the state level, already in 2025, we've seen states seeking to amend telemarketing laws to kind of create more teeth, to allow businesses to register on do not call lists. We've even seen a few states introduce, what we call these mini TCPA laws that required some type of advanced consent for certain automated calling practices. All that being said, seems like there's a lot of movement, whether that's in response to a few of these cases that we've just talked about or what. But Michele, what are states doing? What's federal Congress doing? Where will we land here at the end of this year? What's going on in the legislative state right now?
Well, Aaron, I would turn that question over to you, because those of you that don't know Aaron might not know the fact that every day he comes to the office and probably the first hour of his day is spent doing legislative monitoring. So he monitors everything that has happened in the previous day, and then he updates that and informs us if there are any significant changes. And so, Aaron, what are you seeing out there? Is anything already being introduced now that we're at the beginning of the new year? And as Aaron mentioned, we're in a new federal Congress now. So all of the bills that were pending at the end of last year, they're gone. They have to be reintroduced. Each state has a different way of handling that, whether the bill carries over or if it also ends and has to be reintroduced. So are we seeing any interesting activity already, Aaron?
Well, certainly have. There were a few that legislators that wanted to jump the gun and pre-filed bills last year. As I've mentioned, South Carolina has that mini TCPA bill that would require prior express written consent to make telemarketing calls using an automated system for the selection or dialing of telephone numbers. At the end of last year, New York amended their telemarketing disclosure timing requirements. New York also has a bill that was just recently introduced in this legislative session that would expand certain telemarketing prohibitions to robocalls. We've also seen other states update telemarketing laws to include business subscribers as the beneficiaries of the bill, and to amend certain definitions to ensure that text messages are incorporated in the bill. So lots of movement. Spencer, on your end, do you think that we could expect to see increased legislative activity depending on the outcome of either the McLaughlin or the IMC case?
Yeah, so I do think we're likely to continue to see legislative efforts in this area. I don't think that is by virtue of anything that may happen in the IMC case or in the McLaughlin case. It's just a simple matter that folks continue to receive a lot of unwanted calls. Now, FTC says that's trending down, but there's still a lot out there. And even though, I tend to think it's an enforcement problem, those who have to report to their constituents and explain why this is happening are going to continue to try to address this through legislative means. So I do not see it going away.
And Michele, your final thought, what's your thoughts on legislative activity pending the outcome of these cases?
Yeah, I mean, you guys have already said it. The states will definitely feel compelled in the absence of federal regulations and federal laws to fill in those blanks. We've already seen it. We saw that with the definition of what constitutes an auto dialer. So I suspect we'll continue to see that. And I mean, I think the only thing that we can really count on moving into 2025 now is that litigation is going to be up. And just really want to reiterate how important it is now more than ever to just really have your compliance completely buttoned up. And Spencer, I want to thank you so much for coming on here with us today. Really enjoyed it. And like I said, you're one of the brightest guys I know in the industry. And it is always a pleasure to present with you. Thank you.
Well, I appreciate it. Thank you, Aaron. Thank you, Michelle.
Yeah, likewise, it was an honor being on a webinar with both of you. Very humbling. You two are incredible. I look up to both of you. Really enjoyed this one. To wrap this all up, we thank all of you for joining in with us. We hope you found this as informative as we did. If you do have any questions, feel free to email me, aparry@mslawgroup.com. If you have a specific question for Michele or Spencer, I'll be sure to get it to them. And as always, we look forward to talking to you again soon. Thanks a lot.